Good morning, good afternoon, and good evening to everyone. As I said, the first day that I intervened, my apologies for not being there in the session. Previous commitment didn't allow. I'm now far away in The Hague, so it's for me it's good afternoon. As is indicated in the agenda, and I mentioned this in Monday, in the first day of our session. What we have to do now is to have a roundtable discussion about the colloquium that we have had during this week, in order that in the roundtable discussion, the working group would consider possible future work in order then for the Commission to look at our discussion and consider and decide what would be possible future work for the working group. In that regard, I want to remind that this is the purpose of this roundtable is not to decide on future work. It's not our task to decide on future work. That's the task of the Commission. It's just to provide input and insight of what the working group thinks after having this colloquium during this week about what are the possible avenues for future work. As I said also on Monday, based on our discussion this week and the discussion that we will have now in the roundtable, the Secretary will prepare a report, and that report will be in front of the Commission to further consider these matters. The way in which I propose to have our discussion is the following. First of all, I want to say that considering, how many times here that we have to be expeditious and act with efficiency in arbitration and the different type of disputes that has to be considered, in all of the topics the word efficiency appears. So I would suggest that we will be particularly efficient today, and we will finish in the morning session our discussion. I'm sure that you there and others online will favor the possibility of finishing, before the lunch break. I see that feasible. I think we have had already some discussions, and I consider that it's perfectly possible that we can have our roundtable during the 2 hours of what is the morning session in New York. I'm sure we will be able, as we have done in previous occasions, to achieve that. The way in which I suggest we proceed with the discussion of the roundtable is that I would like to give the floor for 5 minutes to each of the moderators of each of the 4 topics that were in front of us for the colloquium during this week. And I suggest that I will give the floor to them in the order that we discussed during the colloquium each topic. After the presentation of each moderator, I suggest that we have a discussion among the delegates and the working group about, as I said, what is the views of the working group with respect to these different topics and the possible future work or our possible future work. In any case, after the 20 minutes or so of the presentation by the moderators, I would like to give some remarks of the impressions that I have had during listening to the discussion this week, and offer a certain points for discussion for the working group to consider. So if that way forward is acceptable to you, without further ado, I suggest that I give the floor to our Madam Secretary, Anna Jovan-Brett, so she will make us a summary of the first topic, which is DRTE, the dispute resolution in the digital economy. Somehow I see people nodding in the room. I sense people nodding. So with that, as I said, Anna, please, you have the floor.
Thank you very much, Chair, and I admire your ability to see virtual nods. But indeed, there is a strong sense in the room that you are guiding us well through the last day of our session. So I had the pleasure of moderating the first part of our colloquium, which was looking into the different topics that have been identified for the DRDE project, and particularly for the stock-taking exercise. That is the objective of this project. We wanted to discuss with the working group whether we had captured the right issues for the DRDE project, and also discuss briefly methodology for conducting this stock-taking exercise. So we've heard from a number of speakers about the experience of using technology to overcome the problems generated by the pandemic. And particularly, we heard a lot about virtual hearings, we heard about protocols for virtual hearings, we heard about the technological experience with virtual hearings, we heard about witness examination in a virtual context, and we heard from two sets of speakers, two practitioners and two working group 2 delegates, how they view this use of technology to support and to make it possible to hold arbitrations in a virtual context. What we also heard, and that I would say was the aspect that goes more into the following session, but we also heard about the increase of technological solutions that can either support but also provide similar services than of dispute resolution. And we heard about the use of platforms in order to conduct dispute settlement, but also to facilitate with conference management, with holding and of evidence, with case documents. And so we could see that, as was remarked by Toby Landau and Lisa Alm, technology is not only a tool that has been used successfully in arbitration proceedings, but it has also potential to further to broaden the offer of dispute resolution, and this was an aspect that we looked into as well. So in terms of methodology, what we discussed very briefly, but I think that we will include that into our report, is to approach these technologies not from the technology point of view, but rather from the way they can either support, facilitate, or disrupt arbitration and other forms of dispute settlement as we know it. And looking at that, we would then see how existing UNCITRAL texts are actually impacted by these new technologies, and whether from there we identify needs for additional provisions, additional texts, or additional standards to accompany this shift in the importance of technology in international dispute resolution. So that's pretty much what I wanted to summarize for you, Chair. And again, we have our work cut out for us in the DRDE stock-taking project, and we benefited from the various interventions and the examples during the session to guide us in this stock-taking activity that we will begin at after the Commission session. Thank you very much.
Thank you very much, Anna, for your clear and concise presentation. I think that it reflects very well what was the discussion, and as you said, and we can discuss this briefly later on, it put before us, certain challenges with respect to methodology and obviously to capture the right issues. And I think the summary you provided goes exactly on that line. So having said that, now I would like to give the floor to our second moderator. I understand that our second moderator is online, right?
Chair, actually, James Ding could not make it. I will actually deliver the summary by James Ding on his behalf.
Okay, so please, Jay, go ahead.
Thank you. Mr. James Ding, who's moderated the session on online dispute resolution, was not able to make it, and therefore he sent us his summary. And I will also summarize his summary because it's a bit long for the 5 minutes. So session 4 of the colloquium focused on online platforms for dispute resolutions. Reference was made to the project by the Department of Justice, which we refer to as IGLIP on ODR, and that the Secretariat had continued to participate in this IGLIP project. Discussions that were held during the second meeting of the IGLIP on ODR was summarized in working paper 223. And some of the elements there were actually touched upon by the speakers. The speakers also discussed, the experts of the IGLIP had discussed how to explore the development of an international legal instrument that could facilitate access to justice through the use of ODR internationally and set out minimum core standards that would apply to ODR proceedings, ODR providers, and ODR platforms. And a number of those issues were touched upon by the speakers of the colloquium. The first presentations explained how online platforms were used for trade as well as for resolving disputes, in particular on ODR. A reference was made to the platform economy, and the two different types of ODR platforms were highlighted. One, platforms which built-in mechanisms to handle disputes between users and between users and the operator, and ODR platforms which were solely provided for ODR services or dispute resolution services. Relevant issues for further considerations were pointed out, like internal policies of the platforms, valid consent, recognition and enforceability, applicable law, redress, and appeal mechanisms. Discussion next to the sharing of practical experiences in operating ODR platforms in different regions in the US, in Colombia, and Chile, and challenges faced by those institutions, for example, with the lack of legal standards were mentioned. Challenges also faced by implementations of ODR standards, including legal limits in the different jurisdictions, budget constraints, the digital divide in rural and urban areas, as well as issues with the different systems of each private company operating in different jurisdictions were also mentioned. Their work in developments to resolve B2B and B2C disputes were also shared, and it was emphasized that their work would be relevant to an international legal instrument on setting minimum standards on, and intentions were expressed for continued contributions in their efforts. The next area of presentations focused on challenges faced by ODR and ODR service providers, and it was considered that ethical standards or best practices should be created to ensure that using technology to expand access to justice would not instead limit access to justice. The work of other organizations on ODR standards making were also mentioned, and it was noted that ethics or standards should be considered at the outset and not simply as a reactionary measure. It was hoped that efforts to promote ODR and access to justice would also continue. Then we also heard about the critical perspectives about the existing UNCITRAL notes, the technical notes on ODR, and what was missing therein. And there were reference to other developments in APEC and ISO on how the technical notes could be supplemented and complemented in our future work. Just a few points that were mentioned in the discussions. The issues were of importance was how to deal with small claims and the claims of MSMEs in ODR, the blurring line between consumers and sellers and B2B and B2C disputes, and that there was also a cause for additional work to be done, and reference also was made to existing text, particularly done by APEC. There were also calls that the work should focus more on the commercial aspects rather than on the normative work, with the gathering of additional information on ODR and whether parties have been using technical notes. It was expressed that there was already a lot of available data on ODR, and researches should be conducted throughout the world to collect data on what has happened since the technical notes. But there were also doubts expressed about the fact that the circumstances that delayed or prolonged the discussions on the technical notes still existed in the current environment, and that the issue might not be ripe for discussion. The issues of enforcement mechanisms on the ODR awards and decisions was also made, and reference was made to the use of technology for those enforcement as well. So I think that is a summary of what we had discussed in session 4 on the ODR platforms, and I would like to pass the floor back to you, Chair.
Thank you very much, Jay. I think that was a very comprehensive, and even though it was succinct, was took into account all the different aspects that we heard during the different session on what are the issues of ODR and how these issues are relevant to dispute resolution, to different regions, and what are the legal but also some technical problems that appear into the online dispute resolution. And that gives, I think, the working groups clarity about what was the discussion about. Having said that, I would like to give you the floor back to you now. No, to Judith first, I think. It's Judith first. Sorry, Judith. It's to Judith first. Judith was the moderator of the adjudication section. So Judith can give us the report or the summary of the discussion that took place with respect to the issue of adjudication. Judith, please, you have the floor.
Yes, thank you very much. And it's indeed my pleasure to report on the session we had on Wednesday on adjudication. So we first had the rationale for the Swiss proposal as outlined in our working paper 225. And we heard what the aim of this proposal was: to have an expedited and summary proceeding which would result in a decision that would need to be complied with, but could be challenged in a full-fledged arbitration under the UNCITRAL arbitration rules. If successful, the adjudication would allow the claimant to secure prompt payment, but still would allow the respondent to challenge the decision. So what the adjudication would do is revert the creditor and debtor position and allow for cash flow so as not to disrupt or cause any additional delays to the project at hand. The respect for due process, for fairness of the procedure and rapid decision-making were seen as the key advantages of adjudication. And it was underlined that in order for a contesting party to reopen an issue and submit a dispute to arbitration, it must first comply with the decision of the adjudicator. We heard different national experiences from the UK, from Canada, from the Philippines, from Singapore. And we heard that adjudication was a successful tool in many jurisdictions, mainly in the domestic context and mainly in the context of the construction industry, but could possibly be equally useful in disputes for long-term contracts with recurring payments, such as license agreements, long-term delivery contracts or like, or in other words, where cash flows during ongoing projects would be key and where there would be a preference for speedy solution over necessarily correct or precise solutions. Additionally, we heard that the decision was usually satisfactory for the parties and consequently accepted as the final decision, and that the number of disputes in that field in those jurisdictions where legislation on adjudication has been adopted drastically diminished. It was reported that businesses requested tools like adjudication, for example in Canada, and that where they were introduced, adjudication developed much more rapidly and in a way that was not expected initially. We heard that adjudication existed not only in common law countries, but that, as shown by the example we heard of in Quebec, had been successfully introduced in a civil law jurisdiction. It was also mentioned that tools that would achieve a similar effect of securing an expeditious payment with a subsequent procedure existed in many jurisdictions. It was further mentioned that in jurisdictions without such statutory adjudication, it would be possible to hold adjudication governed by contracts. It was emphasized that such inclusion would have significant economic benefits. However, due to the lack of adjudication legislation, such adjudication decisions could not be enforced as easily, and it was stressed that such uncertainties could lead parties to abstain from adjudication, which could be perceived as merely causing additional costs. We heard that these concerns were supported by case law. It was reported that cross-border cases based on contractual adjudication were indeed occurring, mainly for two reasons. The adjudication decision not being enforceable, the claimant in the adjudication had to pursue with arbitration, or if the parties failed to put in place an adjudicative body at the beginning, and as no mechanism was in place to appoint an adjudicator after a dispute has arisen. So as a general point, it was suggested that future work on adjudication should be based on the need of the users, the industry, the businesses, and on the feasibility of the work. We heard some support for the exploratory work, and we heard some support to take up work with a possible focus on, first, adjudication or similar procedures as an efficient means to solve disputes in long-term contracts generally, as well as, second, the means to ensure enforcement of provisional decisions. We heard about possible forms of the instruments to be developed, ranging from contractual model clauses, arbitration rules, legislative provisions, or even a convention. We also heard some reservations stating that adjudication would generally be regulated better in domestic legislation or contracts, and as the concept was unfamiliar to many jurisdictions, that it might be difficult to achieve harmonization. And with that, I would like to give the floor back to the chair. Thank you.
Thank you very much, Judith. Again, I think your presentation was very thorough and comprehensive, and you were able to identify the different issues that appear from the comment of the expert, but as well as from the remarks made by the different delegates. I think that gives a very good background for the discussion that we will have later on this issue. Thank you. So now I will give the floor to the last moderator, which is Jay, who moderated the section devoted to the draft provisions for tech disputes. So Jay, you have the floor, please go ahead.
Thank you, Chair. As you know, sessions 6 to 8 on Wednesday and Thursday focused on technology-related dispute resolution, and the participants considered the draft provision prepared by the experts as part of what we call the brainstorming exercise. At the beginning, it was felt that the number of disputes that involved issues of technology was rising, and that there was a need to examine how the current standards could be used to resolve such disputes or provide guidance to the arbitral tribunal and the parties to tailor their arbitral proceedings. In that context, it was felt that the draft provisions for technology-related dispute resolution, as provided in document ACN 9 Working Group 2, Working Paper 224, shed some light on the relevant issues, and they stimulated the discussion during the colloquium. It was felt that the framework in which the draft provisions would operate needed to be clarified. For example, whether it would complement or possibly replace the UNCITRAL arbitration rules or the recently adopted UNCITRAL Expedited Arbitration rules. With regard to need to have a simplified process with a shorter time frame, some support was expressed for suggesting the UNCITRAL Expedited Arbitration rules as the framework, as it provided the necessary shorter time frames, including for the rendering of the award, and at the same time provided the flexibility for the tribunal and the parties to tailor them to the needs of the case. While the form of the final product was yet to be determined, doubts were expressed on preparing a separate set of rules that would be governing for technology-related disputes. Rather, preference was expressed for preparing model clauses for use by parties or a guidance document on how the UNCITRAL text could be tailored for such dispute resolutions. In particular, there was some interest to develop model clauses on the appointment of experts and neutrals, confidentiality, a shorter time frame for rendering the award. Based on the discussion, it was noted that while the definition of technology disputes, as found in draft provision 1, could illustrate the context in which the draft provisions as developed could operate, there would not be much merit in defining the characteristics or defining or characterizing the type of disputes such model provisions or clauses would apply, as their application would generally be left to the parties themselves to decide. It was also noted that there would be difficulties in outlining the scope, as the parties to technology disputes could range from a startup company to states, and as the technology itself were constantly evolving. It was also mentioned that technology was increasingly becoming part of the transactions and that it would be cumbersome to delineate a dispute that was technology from that was not technology related. With regard to a number of arbitrators, there was some support for a sole arbitrator, yes, supported by those with the technical expertise, either by the parties themselves or experts appointed by the parties or the tribunal. And at the same time, it was noted that the parties should have the flexibility to agree on more arbitrators, particularly when a case addressed more complex issues. With regard to case management conferences, it was generally felt that some guidance on the issues to be discussed could be useful, as provided in draft provision 3. It was also noted that issues dealt in other provisions, such as the appointment of the experts, confidentiality requirements, treatment of digital evidence, and shorter time frames would need to be discussed during such case management conferences. And considering the significant role that experts would play in technology-related disputes, it was felt that their appointment process and their role in the arbitral proceedings would need to be explained and clarified. It was further mentioned that their interaction with the tribunal and how their findings and determinations were to be treated in the proceedings might need some guidance. There was some interest in further developing draft provisions 6 and 7, respectively dealing with outbound and inbound confidentiality. It was mentioned that the UNCITRAL framework for arbitration did not necessarily address confidentiality and left it to the agreement of the parties, while rules on transparency have been developed in the context of investor-state arbitration. Considering that technical and commercially sensitive information lied at the heart of technology-related disputes, some support was expressed for developing clauses on confidentiality for use by the parties, although the draft provisions needed a little bit more elaborations and clarification. As to draft provision 8 on evidence, it was noted that clarifications that data and technical information could also consist evidence would be useful, while some doubts were expressed about specifying the form of taking evidence. With regard to paragraph 3, which dealt with the parties' use of technology, including artificial intelligence, views were expressed that the provisions to be developed should not aim to regulate or prescribe the conduct of arbitration, particularly in light of possible developments in the use of technology, and rather that the approach should be more flexible. This aspect of preserving flexibility was reiterated throughout the deliberations on the draft provisions, not only on 8, but also on the other provisions. Lastly, on the period of making an award, it was generally felt that a swift resolution of the disputes would be ideal. For example, in the context of technology-related disputes concerning software development and financing of startups, and some concrete examples were shared. It was felt that such examples could usefully guide the work, and some support was expressed for providing default timeframes for very short periods as outlined in draft provision 9. On the other hand, some doubts were expressed about the usefulness of imposing such a short time period for a broad range of disputes as identified in draft provision 1, particularly none knowing the complexity of the dispute, the experts to be engaged, and the measures to be put in place for confidentiality and so forth. It was also mentioned that imposing shorter timeframes in an ad hoc context may also be quite difficult. Furthermore, while reduction of fees and other sanctions may incentivize the arbitral tribunal to manage the proceedings effectively, some doubts were expressed on the regulatory nature of such provisions, also noting that such a provision may limit the pool of arbitrators that would be willing to take the case. The participants expressed their appreciations to the experts that prepared the draft provisions, and they considered that it provided a good basis for the discussions and stimulated our thoughts. Calls were made to provide more concrete examples of cases which had the peculiarities of the high-tech technology-related disputes, highlighting the need for a quick resolution of the disputes by a person with expertise. And some support was expressed for the Secretariat to continue to work with the experts in preparing a more elaborated version of the draft provisions. Also taking into account the experts from different regions of the world. So that is a short summary of the discussions that took place in sessions 6 to 8. Thank you, Chair.
Thank you very much, Jay, for this complete report on what was the discussion on the draft provisions or the brainstorming around the draft provisions prepared by experts related to tech disputes or technological disputes. Before starting our discussion and give the floor to the delegates, I would like to say a couple of things with respect to what we just heard. The first thing that I want to say is I would like to remind the working group that I asked the Secretariat to prepare a report on early dismissal or preliminary determination. That report will be in front of the Commission in the summer session. I just want to remind that, but please, it's not the intention that we'll have any discussion at this moment about early dismissal or preliminary determination. I just want to remind that already this would be in front of the Commission, and I mentioned this because precisely this roundtable is to discuss what it or to seek the views of the working group with respect to the future, our future work. The second thing that I wanted to mention, and I would like to offer, is that it seems to me, after listening to the different reports, that we have in front of us two different types of possible tasks or works or projects, right? The first one, which is the DRDE and the ODR, it seems that there are projects that somehow are clear in the sense that belong to a stock taking. This is a word for the Secretariat. It's not the work for the working group. Nonetheless, of course, this at some point may come back to the working group if the Commission so decides. But it's basically something that is a work that will be conducted by the Secretary as the work has been outlined and explained during the discussion and summarized by our Madam Secretary. So in the way in which I see it, and I would like to invite any comments in this respect, is that with respect to the DRDE, but also with the ODR, we have projects that somehow can belong to this idea of the stock taking in disputes related to the digital economy. I see that these two projects are distinct and they should have independence, each one. They can take separately and can be coordinated, of course, at the level of the Secretariat in the stock-taking effort. I also think, and I would like to offer the word in a few minutes to you, that further, I would say, definition of what is the right issues to be addressed in the DRDE, as well as I would say in the ODR, and also about methodology, it would benefit the project. This project will be in any way an ongoing project, and this is something also that can be done along its along the progress of each of these, as I said, in my view, independent projects, but are sufficiently defined and clear on what they are and what would be the role of the Secretariat of UNCITRAL in conducting them. So what I would suggest is that we start with the discussion about these two, and then we move into the discussion of the other two, which in my view have different issues to be discussed. So if that is agreeable to you on what I propose, I would like to offer the floor to the distinguished delegates with respect to our two first topics, the topics that I will, let me call this way, they belong to a broader idea of stock taking by the Secretary with two, as I said, separate independent projects, but connected at the level of the subject matter. And here, any views that the working group, the delegate may have on this, and any contribution that they would like to make in order to the issue of what are the issues that should be covered, and also about possible methodology. And then we can move to discuss the other two topics. So if that is acceptable, I would like now to give the floor with respect to these two first topics, which, as I said, it seems to me that are clear with respect to of its future work. That is work for the Secretary, and it's not for the working group. So I would like, please, Jay or Madam Secretary, if you can help me if I don't identify from the virtual view who is asking the floor there in the room, and I assume that I will get maybe in the chat, as always I do, an indication of who is asking for the floor, so I can give it in an orderly manner. If it's necessary, please intervene and just let me know, and we will give the floor to who corresponds.
Yes, we will provide you the list in the chat. Just to add to what you mentioned, we hope to continue to engage with the experts that we have done in the past. And we have taken note of the fact that we need to we need to listen to experts from the different regions, as I just mentioned, for technology-related disputes. And we hope to do so and we'd like to invite experts in this working group to also indicate their interest in participating in these work. Thank you.
Thank you very much. You refer, of course, to these two first issues, right?
Yes.
So topics. Yes, that's correct. I think if I may add on this, just the importance of and the grateful that we are that the expert wants to engage, but the importance that the Secretary will be able in developing this work, in engaging with experts and keep the discussion, and the experts keep participating here in the group, on others that would like to contribute to participate in the development of these two issues. I see a request by the floor I think I have the first request I have is from Singapore in the room, and then I see the hand of the Japan delegate Takashi Takashima. Singapore, please, you have the floor.
Thank you, Chair. Our delegation has listened very carefully with interest to the rich and excellent presentations that have been made in the course of this colloquium, and the thoughts and the ideas shared by working group delegates. On the DRDE, we have a short intervention. As mentioned at the outset of the discussions, our delegation supports the DRDE stock-taking efforts. We agree with the views that have been shared in the course of our discussions, that the shifts we have observed in the digital realm as a result of the pandemic and with rapid development of use of technology, that these pose stresses on our conventional modes and models of dispute resolution, which had been developed over time with assumptions premised on in-person proceedings and hard copy documentation. And our discussions over this past week present to us the opportunity to reconsider our assumptions and redesign processes and rules to embrace technology and what it can offer, and also recharacterize arbitration, mediation, and the whole continuum of ADR processes. On the questions that are posed in the DRD paper, we think that there is scope for deeper dives into specific guidelines or best practices to ensure equality and fairness is preserved where technology is adopted or used in the context of dispute resolution. In particular, preservation of the integrity of online hearings, document exchange, and witness examination. There is also scope to study if there are any gaps or areas that have arisen as a result of technology or digital means that require a further updating of existing rules. Thank you.
Thank you very much to the distinguished delegate of Singapore. I have next our distinguished rapporteur and delegate of Japan. It's a pleasure to see you, Takashi Takashima, and after him I have Israel on the list.
Likewise, Mr.
Please,
Chair.
you have the floor.
And thank you for the floor. Yes, I shall begin with your summary or how you characterize these stock-taking activities. I think we are pretty much on the same page. It would be an activities to be carried out, broad activities, stock-taking activities to be carried out by the Secretariat. And with that in mind, I think it would still be useful to provide some input to the Secretariat in terms of methodology. And my first point pertains to something that I had already mentioned earlier in the discussion, but I would repeat this point that listening to the presentation by speakers and interventions by delegates, we thought that with respect to some suggested stock-taking topics, such as online hearings, witness examination, and means to address the flood of information problem, it may be beneficial to conduct relevant activities in a way that it would facilitate and contribute to the consideration of those topics by the Commission as possible future working group to work in the future, as you suggest, Mr. Chair. And while we need to thoroughly study it further, the interim measure topic was an interesting one, and which may also belong to that category. Going into my second point, it is by a coincidental convergence that Madam Secretary suggested during the discussions, which was nicely summarized today, taking the taxonomy kind of approach taken in working group 4 work and applying it to stock taking possibly, which was something that vaguely came to my mind in the course of discussions as well, not least because I will be following the AI and data transaction work taking place next week during the latter half of the working group 4 session. Drawing from the studies carried out by ICC, IBA, and other entities, it may be advisable to start by creating a categorical compilation of available technological means in arbitration, which may be followed by a note on how they are dealt with by existing UNCITRAL instruments with a view to identifying loopholes to be addressed. also through carrying out study on practices on the ground. It could also be accompanied by notes on actual issues, including on due process unfairness, confronted by parties and tribunals in leveraging those means. These are my comments, Mr. Chair, and I will stop here. Thank you.
Thank you very much to the distinguished delegate of Japan. If I may just say a couple of words of what he said, I think that he came back to what the Madam Secretary said in the first day, which is taxonomy. I think it's a very proper way of looking at this, because the risk of a project like this, obviously, and this is why the methodology is important, is that there are too many issues at two different levels with different content. So I think it's very important, as I said, to have an exercise, to start with an exercise of compilation and taxonomy to see what are the different avenues of work that can be carried out starting from there. So I think that it's very helpful to hear from what the distinguished delegate of Japan said about precisely how to identify the right issues and how to introduce methodology to the exercise. I have next Israel. Israel, please, you have the floor.
Thank you, Chair. In this opportunity, I would like to thank again to the delegation of Japan and IGLIP for the proposals and truly interesting and educating presentations. We definitely support that the Secretariat continue to conduct research and follow recent trends on those two topics. We would also support the proposal by the distinguished delegate of Japan to expand the stock-taking project to include interim measures, as well as judicial assistance to tribunals, including in aspects of enforcement. We would suggest, however, that with the time, the Secretariat would focus on the most relevant issues, so the working group would have an infrastructure for future work in the future. Thank you.
Israel, sorry, thank you very much to the distinguished delegate of Israel. I think if I understood from the intervention of the delegate of Japan, the idea of incorporating, as you said, into the possibility of interim measures or issue of enforcement is something that may be included in as the work develops, and precisely as the taxonomy and compilation takes place, in order to see as well, within this broad work, what should be the priorities that the Secretary should take in advancing its work in TRTE. I have in my list Mexico, Republic of Korea, and I see the hand of Canada as well. Mexico, please, you have the floor.
Muchas gracias.
Thank you very much, Chairman. Just 2 points on these issues where you've asked us to make some comments. The first is that when we have the possibility of creating instruments, guides, notes in areas of technology, we must be very cautious. And this is something that a number of participants and delegations have raised earlier. We must not be predicting how technology is going to develop. We have to be very cautious about getting into specific issues, including in the way we word notes or guidelines. My second comment is the contribution that UNCITRAL can make in these two areas, I think, is to identify, how to take care of due process issues before these new ways of dispute resolution develop. Perhaps that's really the approach. So we shouldn't be getting into the technological issues per se as to how the hearings will develop, how the witness can be questioned how the confidentiality is going to be ensured. That's quite important, but it's more a question of our approach to harmonizing this work, and that's what UNCITRAL can do, is to make suggestions how to ensure and observe due process when these measures are used. Thank you.
Muchas gracias al
I thank the distinguished delegate of Mexico.
solamente
I would just like to point out with regard to what that he has said is that due process is indeed one of the issues that was identified in the working paper, and it's also been identified by the various briefers and experts as a very important issue. I also said that we mustn't lose sight of one important aspect of arbitration, and that is to provide justice and to provide a settlement to a dispute in a fair manner. And I would simply add on that point, as has been explained, the stock-taking approach includes a number of stages. So notes and guidelines are things that don't really necessarily happen just at the beginning of the process, but they can evolve over time. As the Secretariat of UNCITRAL has said, we need to have approach it, take the taxonomy approach and have a list of issues that need to be addressed and catalog them appropriately, and then find the ways in which we can ensure that that the work moves forward.
la próxima.
The next request is from the Republic of Korea and then Canada.
Please.
Thank you, Chair. As it's my first taking the floor, I would like to extend my appreciation to Madam Secretary and the Secretariat for coordinating fruitful colloquium this week that provided a variety of information regarding the LDE and others. My appreciation also goes to the excellent presenters who shared their experiences and views. The digitalization of dispute resolution has been in progress even before the pandemic, and the pandemic has led it to rapid progress. Last Monday and Tuesday, we had a great presentation on experiences related to dispute resolution in the digital economy in various countries. However, it looks rather early to make a full-fledged legal instrument for the LDE because experience with the LDE has not been sufficiently accumulated. In this regard, the stock-taking project, thanks to the distinguished delegation of Japan, is very useful to identify the core elements to be addressed in the possible instrument. For our work to be efficient and workable, I think it is necessary to narrow down the scope. From our view, the possible legal instrument should focus, among others, on minimizing the negative impact of the LDE with regard to the digital divide, equality and fairness, and flood of information and due process. Thank you.
Thank you very much to the distinguished delegate of Korea. Canada, please, you have the floor.
Good morning, everyone. And thank you to those that have spoken before me and to the moderators that give us a very succinct summary of the very rich and comprehensive contributions that we've had this week. Canada would support continuing the stock taking or the taxonomy in DRDE, and we think the advantage of doing so is that it's really going to allow the working group and the experts to keep appraised of the latest developments. It keeps our minds open and an eye on opportunity for future work that may emerge. If there's time, maybe the Secretary could explain perhaps the difference between stock taking and taxonomy. To us, they're a little bit of the same, as long as we keep a broad eye on developments, and it allows us to keep informed and to examine, I guess, be open-minded to what the future work may be. Thank you.
Thank you very much to Canada. If I may, just to say a couple of words, because I have used the word taxonomy more than on one occasion. As I understand, taxonomy is part of the stock-taking exercise, not different than. It's precisely, one step that you take in order to put the information in order and understand what are the different issues and where each issue belongs to. But of course, I will let the owner of the word to explain, but that's my understanding is the way in which I have used it. So I will now give the floor to the Secretary.
Chair, there was a request by the United States, so we would like to give the floor to the United States first. And just to let you know, on the platform, there has been a request for somebody who has not been identified with raising the hand. We cannot give you the floor until you actually follow the naming convention. So we'll just mention that.
Yeah, I saw, and I think has been a comment on the chat on that regard as well. So, okay, so I'll give the floor to United States and then to the Secretary. United States, you have the floor, please.
Thank you, Mr. Chair, and thank you again to the Secretariat and the experts and presenters on the topics of both the DRDE and ODR. Like other delegations, we are pleased that the stock-taking exercise will continue. We think it's an excellent way for us to get our hands in a meaningful way around these issues. And I think I share perhaps Canada's question about exactly the difference between stock taking and taxonomy, but as I understand it, I think as long as the taxonomy exercise helps us understand the problem and doesn't become a straitjacket, then it's a very useful way to go forward. In terms of the stock taking as well, just to comment that as we had during the discussion, that we do think that we also need to be mindful of the relationship between courts and arbitration in the digital space, as we had mentioned, and so we hope that that will be worked into the existing categories that have been identified for the stock taking. I had one question, so I'm glad that the Secretariat will follow me, because as I understood the Chair's suggestion, is it that, or I may not have understood the Chair's suggestion, is the thinking to add to the existing DRDE as a part of the stock taking of ODR practices as well, or is that going to be a separate stock taking exercise? It did seem like it was useful, though, to also perhaps do something like that in the ODR space, because we heard a lot about the types of developments and work that is going on in that area, but how or whether the notes that have been developed by UNCITRAL are influencing that process or are being useful, seems to be a good question. So again, I think we would help benefit from a little bit of clarity on what what aspect of ODR may or may not be included in this exercise. Thank you.
Madam Secretary, you have the floor, please.
Thank you very much, Chair, and thank you to the distinguished delegates of Mexico, Canada, and the United States for raising issues on which I would like to now give you our views. So first, regarding Mexico's comment, it is indeed the intention not to get carried away by technology and not to start regulating technological issues and applications to dispute resolution, but rather to be, as was suggested by Lisa Alm, the guardians of the galaxy of integrity of arbitration and mediation processes, and ensure that the technology does not disrupt, and particularly from the point of view of due process and the principles that underlie, that support dispute resolution. So that is a point perfectly clear for the Secretariat, and thank you very much for emphasizing it for us. The second question relates to taxonomy. Yes, so I'm using this as to flag that we will need some methodology in the stock-taking exercise, because as we've seen, only from the first day we had 25 different interventions on elements that are relevant to the stock taking, and indeed we could have much more. So the thing for us will be to put some order and methodology, and the idea of linking this to the approach we took for taking stock of the technological evolution, impact, and possible disruptions to international trade was a good way of, for us of approaching it, so that we do not get once again carried away by the technology, but that we remain very focused on dispute resolution, what technology can bring to dispute resolution, and how technology is beginning to offer dispute resolution, which brings me to the second point raised by the distinguished delegate of the United States. Indeed, we have two projects that are ongoing which involve the Secretariat. One is the DRDE project, which was proposed by Japan and for which Japan is making a contribution to the Secretariat. And we have the longer-standing cooperation with the IGLIP, which was launched by the Department of Justice of Hong Kong, SAR. So we have indeed the intention of reporting back to the working group and to the Commission on the advance of these two projects in a comprehensive, holistic manner. We're not going to look at it on one side and the other, especially because we've seen the evolution in online dispute resolution between the grievance system for online platforms, which was originally the project that gave rise to the notes that have been produced by the Secretariat, the technical notes some time ago, and the shift towards platforms providing dispute resolution services. So we definitely will have that very clearly in mind, and will report to the working group and to the Commission on both projects under the umbrella of dispute resolution in the digital economy. Thank you very much.
Thank you. Thank you very much, Madam Secretary. I see no further requests from the room, and also no further requests virtual in the all people that are attending online. And also I think that with your last intervention and the question that were raised, we are in a position to move on. I think that we have enough information, and I think the discussion has been very useful in order to provide guidance and understanding of these two projects. So I think that with that, as I said, we can move to our next discussion. Our next discussion is with respect to the other two topics that were discussed during the week, which is adjudication and draft provisions for technological disputes. Before giving the floor, I just would like to say very briefly two things. One, as I said before, to remind the working group that our exercise is not to decide on future work, but give our views as working group. so the Commission can consider future work. And that's obviously is a different, it's obviously a different exercise. It's important that we give our views and what we think and how we see the future work, in particular with respect to these two issues. And the other point that I wanted to make, that in that regard, of course, due regard has to be paid to what is the type of work that typically UNCITRAL does. But also, I think since this is a brainstorming exercise and this is a roundtable, we can also think in a bit out of the box and see, and therefore I invite the different delegates to express their views with a broad perspective about these two topics and the possible future work of our working group. I think with that, I would like to offer the floor with respect to these other two topics and the beautiful future work of our working group. I don't see anyone. Now I see a request from Israel, Colombia, and CCPIT. I think that's from China. Okay, so let's start. I will start with Israel, and then I will give the floor to Colombia, CCPIT, and Spain, in that order. Israel, you have the floor.
Thank you, Chair. And we also like to express our thanks really for all this week. Again, we think this was a very productive colloquium, and I think although it might be better to have more in-person presence by everyone involved, we did manage to have what we think was a useful discussion. And it was yesterday, just to recall that at least for the final presentations, we also heard very good examples and manifestations of why it is important for technology-related disputes to receive some sort of a unique treatment. In thinking about the future and about how Working Group 2 probably could look at both of the issues of adjudication and the technology-related provisions, although they were represented until this colloquium as two separate issues. Listening to the discussions and listening to the different views, we think that they could be treated, possibly could be treated as one, with some distinctions, but we're not sure that we need really to choose between either for work by the working group. We do, however, consider that in both issues it's important that the working group will discuss them, that the working group will provide input. What we saw is that in some cases there is a gap between how the experts that prepared the discussions, that prepared the provisions, and also even the Swiss proposal, there is a gap between what delegates in the working group think and about what is currently the drafts on the table, because as we can also remind, there are basically two drafts on the table. One is the draft provisions and one is the Swiss proposal with also what we think are draft provisions or draft rules. To pick up on what was mentioned yesterday by distinguished delegate of the US, and hopefully she'll be fine with our adoption of her proposal. We think that the way forward, and here we are echoing what you suggested, Chair, about thinking outside the box. The idea, what we propose, is that the working group, together with the experts and together with the Secretariat, and we can further discuss on how exactly that will be. We could discuss it also in the Commission, how to do that. Work on what we can term as off-the-rack solutions for those who are engaged in technology-related disputes or in disputes which can benefit from very fast process like adjudication. We think that there is a very big advantage in that parties would not have to discuss how to develop a confidentiality protocol. They would not have to discuss how to develop evidence. They would not need to discuss timelines or conference management or the use of expertise, because they will have ready-made solutions that they can pick up from the rack, as we say. And in order to have that, I think we need to think about two goals that we should achieve. So on the one hand, we should still highlight in some way that these are provisions which arose out of the need of the technology industry, and they are meant to respond to the technology industry and also to the need for adjudication. And that would be important in our view, because this would allay the concerns that we heard yesterday from technology-related companies at least, and maybe even from those who are only familiar with domestic adjudication. It would allay their concern that the current mechanisms are not suited or are ill-suited to their needs. So I think we think there is a very big advantage to highlight this. So this is one of the goals. The other goal, which we think is very important, if the working group does work on this, and we think maybe 2 or 3 sessions would be appropriate, it would very much benefit the provisions, both for technology-related disputes and for adjudication, will really benefit from the experience of working group delegates and from the further acceptance by the international arbitration community. If we are going down this route, which at least we don't recall UNCITRAL doing this before, not having a complete set of rules, and this is not what we're suggesting, but having off-the-rack solutions, not just at the tail end of the rules, like 1 model or 2 model provisions, but really have like 6 or 7 model provisions that you can take as a whole, or you can take 1, or you can take 2, or you can take 3, and they will just be added to your standard dispute resolution clause. This will be could be innovative. We could even think about a way that people could go on a website or in some form and just take the provisions and incorporate them, maybe even automatically if we want to really think outside the box. So I think we would propose that as a way forward. We don't have any concrete proposals about when that should be. So if it's not in September and we still need to do some work, then of course that would be understandable. We'd like to point out that at least our impression was that the composition of the experts who worked on the provisions of technology-related disputes represented almost every continent and almost every legal system. There might be a need for improvement, but we really like to thank the Secretariat for their very hard work and a lot of efforts on this project, and for really picking up Israel's initial idea with Japan. This is very highly appreciated and not taken for granted. We very much appreciate the efforts to get experts from around the world to do it, and we also like to thank the experts for being able to participate. So at the end of the day, what we envision, hopefully, that by 2024, we'll have a very innovative product and a very useful product for anyone who will face disputes that would require it, with the added value. You could call it symbolic or marketing, but still very important, that it answers the needs of the technology industry as well as the needs of projects which require very fast adjudication. Thank you.
Thank you very much to the distinguished delegate of Israel. I have one short question for you, and then I will give the floor to the list of people that I have, which is Colombia, CCPAT, Spain, Switzerland, France, and I think also I see Finland as well, which is not on my list, but I see the hand. The question to distinguished delegate of Israel is a clarification. If I understood correctly, he mentioned that this is something that could be done as part of the existing rules, if I understood, to use the existing rules, I mean, or modalities or clauses applicable to the existing rules. For example, I would think either the ordinary or the expedited arbitration rules. This was part of your part of your suggestion, if I understood correctly, or you see this as something separate?
Thank you. Thank you, Chair. We see, I mean, we can consider the options, but we definitely see it as something that could work with the existing rules. We just amended the rules very recently, and we amended them a few years before. So we would, at least initially, we would see it as something that works alongside the expedited arbitration rules and the rules. We heard from the industry and we heard from experts that the expedited arbitration rules are useful, but they're not enough to answer the needs of the technology-related disputes and also not the needs of the adjudication. So definitely, we would see these as living side by side, as an addition to both sorts of rules, as model provisions which can be incorporated if these, like anything, if these model provisions are changing some of the, affecting the existing rules, well, you know, then that's what will happen. But we definitely see them as coexisting. So we would not support amending the UNCITRAL arbitration rules or amending the expedited arbitration rules, or to have separate rules for technology-related disputes. At least this is not our view. We would see much benefit in model provisions, but of course, if parties want to say, we want to refer to the 9 model provisions, whichever we'll have, as a package, that could also be a possibility. And that could be maybe the easiest thing, and maybe that would be the most recommended one. But we don't see a problem. We see usefulness even if parties will just say, we adopt the model provision on evidence, or we adopt the model provision on expertise. So that could also be useful. So you can take this package as one, or you can take it, each of them. Like we said, it's like you can take off the rack. You can take the whole closet, or you can take just some of the suits. I hope I'm using the right metaphor. Everybody used metaphors this week, so I hope this one also works. Thank you.
Yeah, thank you very much. I guess it depends on the closet, but yes, I think we understood that. I have in my list Colombia, CCPIT, Spain, Switzerland, France, Singapore, Finland, and United States. So it's a long list. So I ask you please to be mindful of that. And without further delay, I offer the floor to Colombia, please. Colombia, you have the floor.
Buenos días.
Good morning. This is Colombia's first statement, so I'd like to begin by thanking the Secretariat for the excellent work and for this opportunity to speak. I'd like to say that, in point of fact, in Colombia, we are now modifying our statute on adjudication, both nationally and internationally, and we are attempting to promote international adjudication through the adoption of standards such as UNCITRAL arbitration rules, so that we can ensure legal security. In particular, when it comes to DRDE, we are facing a number of challenges, as you are well aware. One of the aspects for Colombia, which perhaps is an area of greatest challenge, is determining of the voluntary agreements in the digital era and the use of these tools for resolving disputes in the digital economy as a solution to these issues, which have arisen quite rapidly as a result of the pandemic. Colombia would like to put forward a few proposals for digital mediation. This is something that the delegate of Israel referred to with regard to the use of clauses we would ask that you consider the possibility of digital mediation clauses that would be included in contracts in the digital sphere, in particular when one of the parties when there are a number of users of the service, that that clause should be included in the contract. And that clause should include, in the case of mediation, that the parties agree that they need not necessarily be present for mediation, but that they should take advantage of all of the technological tools available to them, with which delegates here are all aware. They could use both national and international adjudication because they are using IT, and that is essential for a dispute resolution. There are a number of aspects which require a differentiated approach. We need to train users who are working in this field of mediation and dispute resolution. As the delegate of Mexico said, we shouldn't be speculating about the future as to how technology is going to evolve, but we should be adapting ourselves to those changes and to see how we can use digital tools for dispute resolution so that we can guarantee due process and legal security for users. This is one of the main proposals that Colombia wanted to put on the table with regard to DRDE for users. Thank you.
Muchas gracias a la
I thank the distinguished delegate of Colombia for that very valuable contribution and proposal. We've taken due note of that. I now give the floor to the CCPIT.
Distinguished Mr. Chair, I thank the Secretariat for working tirelessly over the last week, and I thank all the thoughtful views expressed by the experts. Now, I'm going to make my observations and comments on both adjudication and other issues discussed over the course of this week. For example, adjudication has its own advantages, just as experts from the UK, Canada, and the Philippines have shared with us. In these countries, in these jurisdictions, adjudication has been applied extensively because it's speedy and it meets the demand and needs of businesses. However, due to different ways of application in different jurisdictions, adjudication has not been used so extensively in other countries. So whether it is necessary to set out rules for the application of adjudication, well, to answer this question, we need to consider the advantages, the pros and cons of adjudication, and also other types of arbitration, such as expeditious adjudication, emergency arbitration, expeditious arbitration. Well, today, in many arbitration cases, like in Beijing Arbitration Commission, the timeline for completing an arbitration case is just 45 days, which is very short. So whether we need to draft a set of new rules from scratch for adjudication, that is a question. Well, if we use adjudication, say, in the construction industry, and we want to apply adjudication around the world, then we need to understand the pros and cons, its advantages, and we need to conduct a feasibility study on adjudication. That is to say, whether we need to write some rules within the existing framework of rules, or we need to draft a set of new rules from scratch, and whether we need to embed adjudication rules within the existing framework or create a new set of rules. So for dispute resolution, our hope is to settle the disputes within 60 days. Experts can play a role, but it's hard to determine the exact role of experts and their reports. And experts often play an important role in dispute resolution cases. Whether the role of the experts should be written into or embedded into the rules, or they should be set out as another set of rules. Well, we need to understand the legal basis and the usefulness. So we need to first resolve this question, and then we can go one step ahead and discuss how to set the rules. That is, we need to study the feasibility, the necessity, and whether legally it is useful to do that. And regarding ODR, expeditious, arbitration, adjudication, those are my observations. Of course, for adjudication, I have a welcoming attitude towards adjudication, but I think it is still necessary to set some rules on adjudication. But how to link adjudication rules with existing rules, that's the question that we need to discuss and resolve. Thank you so much, Mr. Chair. And thank you all for listening to my opinions. Thank you.
Thank you. Thank you very much for the intervention. I want to notice that I have a long list of requests. There are 9 requests pending, and I kindly ask the distinguished delegates to focus, please, on the way forward with respect to these 2 topics that were discussed during the week. So, Spain, please, you have the floor.
Thank you very much, Chairman. Very briefly, and sticking strictly to the 2 issues you've raised, and I'd like to thank the Secretariat for the enormous amount of work they've done for this week. It is not easy, nor is it necessarily fair to be addressing these 2 issues. As the representative of Israel has said, we find the issue of expedited arbitration rather interesting, because that's something that is needed in practice, and it would allow for harmonized resolutions, and the fact that we can combine approaches in various legal jurisdictions, we think is an interesting idea as well. And we need to determine what the specific issues are that we're going to address in that area, and the approach that we're going to take, and also the sectors we can refer to. I would insist that that leads us, as I say, it's an interesting issue to consider in the future, but we need to determine exactly how we are to channel our work. Or is it going to be a guide, an instrument, a toolbox? We are open to exploring other possibilities as well. Thank you.
Thank you very much to the distinguished delegate of Spain. I think I just want to very briefly also remark that he correctly points out certain issues that has to be considered in this way forward in future work, like the feasibility to harmonization of rules, what other industries can be applied to, a need of rules. I think he points out correctly that there are certain issues that in any case are important to consider. So thank you very much for your brief and very to the point intervention, distinguished delegate. Switzerland, please.
Thank you, Mr. Chair. The discussion we had yesterday was really very useful in bringing clearer to us the needs which the different industries, and in particular the technology industry, sees and expects from us to address. And one of the interesting parts of it is that we have seen, coming from one type of industry, that the technology industry has needs which very much correspond in a different form, though, to those which we have described as the source for the adjudication. In particular, we've understood how clearly and how strongly the need for rapid decision is, but not only rapid decisions, but also in a simplified procedure. And that is exactly what the adjudication procedure has. It has the very rapid solution in a procedure which is simplified and therefore has the safety net of a full-fledged arbitration. And what was reassuring is that we've heard wherever adjudication is used, the solution that is found in the rapid procedure is by far meets a very large part of the needs. We've heard 90% of the users who obtain a decision from the adjudicator will not go on to reopen the procedure. Therefore, we fully support the idea of the distinguished delegate from Israel that the two systems or the two approaches are very much correlated, and that the examination of the two proposals should be taken together. What needs further examination is the manner in which that shall be addressed by the Commission and then by the working group, and what is the target of our work. What we've heard was the adjudication is working well in a number of countries, but that it is limited in its present application to domestic situations because of the regulatory framework. So one of the objectives of the work which we would recommend the Commission to order or to instruct the working group to address is the application of adjudication at the international level. At the same time, the other concerns that have been expressed in the draft rules or in the note and the draft rules for technology disputes should also be considered in a form that the Commission can then adopt as a recommendation or as rules or as proposals for inclusion. And then the question where this will be done, whether in the notes, in rules, or in protocols or similar form, I think is something for the Commission to consider. So in conclusion, this delegation fully supports the proposal of the distinguished delegate of Israel that the two proposals be considered together. Thank you.
Very much. Franz?
Merci.
Thank you very much, Mr. Chairman. I'd like to ask a question that's a bit different regarding our working methods, because we are in a rather particular meeting here, one that is doubly hybrid indeed. It's hybrid in the sense that we have a number of participants that are not in the room, and it's also hybrid in the sense that it's a colloquium, but one that's taking place within a working group. So what are the rules that apply in this case? It's a little bit complicated to grasp this at times. And so this is my question to you, Mr. Chairman, and the Secretariat. In light or in looking forward to the plenary session, what will be the results and how and what form will the results of this session will be presented? Will this be a working group report? Will it be just a summary report from the Secretariat? in any case, it would be very useful to have detailed records of the meeting so that we can address this during the plenary session. Thank you.
I don't know. Well, if in the meantime, what I will give the floor to Madam Secretary to intervene. And
Thank you very much, Chair. No, very briefly, as we had explained at the outset of this double hybrid meeting, we will indeed prepare a Secretariat report, and this Secretariat report will be presented to the Commission, and the Commission will deliberate upon it as it does with the outcomes of colloquia, in order then to decide what it wants the working group to do or what it wants UNCITRAL to work on. Thank you.
Just briefly to add on to that, the materials for the presentations that were made will be provided on the dedicated website. We also have requested that the recordings, not only the audio recordings, but the video recordings are also provided on the website. So in the next week or so, we would like to provide the video recordings to those, because people in the Commission might not have participated in the colloquium and might not be aware of the issues. We will provide all the video recordings on the website. Thank you.
thank you very much. I hope that respond the question. As I said, on the first day of meeting when I open, the discussion will be in a report by the Secretariat that will take, that will reflect the discussion, but will not be a report from the working group, and therefore no report is needed to be adopted during this colloquium. Next, Singapore, please. You have the floor.
Thank you, Chair. On the provisions for technology-related dispute resolution, we see merit in studying provisions that may support the speedy and effective resolution of technology-related disputes, particularly seeing the central role that technology has taken. In devising such rules, if we are looking at off-the-rack solutions, a general point we would make is that we think that it will only be useful to users if we are able to clearly articulate how such provisions may interact with the UNCITRAL arbitration rules or expedited arbitration rules, especially if it is targeting users who are less familiar with using arbitration. On the specifics, we see utility in the provisions that provide for confidentiality. However, with regard to timelines, as was mentioned in our earlier intervention, given the range of disputes that could arise, it may be difficult to be too prescriptive, and flexibility in terms of timelines and the design of such provisions need to fit a broad range of contexts where technology may be involved and would be needed. We also support that timelines could be something that is discussed during the case management conference. On adjudication, as mentioned in our intervention, we are open to further discussions on this, although the practice of adjudication based on Singapore's experience thus far has been domestic and focusing on construction cases, and we would indeed need to explore its international application. And if the working group takes on adjudication as a topic of study, we anticipate that there will also be issues of harmonization and cross-border enforceability associated with an international adjudication framework that will need to be addressed. In discussions, it was observed that adjudication is capable of being applied to other types of commercial disputes. We have not formed a firm view, but we are interested to understand its broader application, which has been mentioned here to include technology disputes. So I agree with the comments of the delegates of Israel and Switzerland that perhaps this could be a link to the work done in relation to technology-related provisions as well. Thank you.
Thank you very much to the distinguished delegate of Singapore. Next, I have on the list Finland.
Thank you very much, Mr. Chairman. I also agree with the Israeli proposal. I think adjudication is something that seems to work well in those countries in which it's applied, but they are mainly used in domestic disputes, and I think there is really a need to have provisions that are in international disputes on adjudication. And of course, there are lots of, I'm not going to these, there are of course some problems related to that, enforceability and such things, but I think this is still something that I from the beginning, I thought it was a good idea, and after having heard these discussions here, I'm more and more convinced that this should be taken on board. However, I agree with those delegates that said that we could in parallel work also with technology-related dispute resolution. That might be a good idea. I think some of these stock taking, we need further work on behalf of the Secretariat. So I think that we should give priority on these two, adjudication and draft provision for technology-related disputes. However, I don't think we should, in doing that, we should not, I think, as many speakers have said, amend the current arbitration rules, even less the very new expedited arbitration rules. I think there is no need for that, but I think this work, these two issues combined should be taken up. So I associate myself to most, if not all, arguments that were presented now by inter alia, the Swiss delegation and the delegation of Israel. Thank you very much, Mr. Chairman.
Thank you very much. United States, please.
Thank you, Mr. Chair. On this topic, as distinguished delegate of Israel noted, we had suggested yesterday that we think about adjudication and the issues and provisions that were the topics of the technology-related disputes discussions holistically and together, because we think abstracting from those two examples, again, will give us perhaps a new way forward. And so we agree with the suggestions that have been made by the distinguished delegates of Israel and Switzerland in particular, that we think about these two processes together, and also that we be open to two things. One, thinking about ways in which we can amplify the existing rules without having to change them. Because I think that is something that we are seeing and is probably going to become more of a trend as we go forward, where we know the UNCITRAL rules provide a great deal of discretion, but it may be that some are not as familiar with how that discretion could be exercised, and that perhaps having a standard, as it were, to suggest how that discretion could be exercised can help make them even more attractive to potentially new users without having to change the rules or limit the existing scope of the discretion as well. And something to that effect may also apply. I know we're not talking about the preliminary dismissal rules, but that's another example of some place where we may want to think about it not as an amendment to the rules, but a clarification or an example of the type of discretion that a tribunal could have, or an arbitrator. And we very much think that this space between when a business relationship breaks down and goes to arbitration, or before that happens, and the space where we want to have a decision that facilitates the continuation of a transaction or a business relationship is an important one for the working group or for the Commission to consider future work on. One thing, though, that I would want to caution on is that I don't think we want to lock ourselves into a particular form. We don't want to use an American reference to a popular movie. We don't want to choose the form of the destroyer, so to speak. We want to make sure that we are focused on the substance first. It may be that we come with provisions. It may be that guidance ends up being the appropriate way to perhaps clarify clauses or address issues that we can't pin down necessarily. The provisions that we saw for our discussion on the technology-related disputes were very helpful, But I think if we were going to actually have commented and negotiated them, I think it would have raised a number of issues that we would have been concerned about. So I think we need to, again, be flexible. But with those caveats, I think we see a great deal of merit in pursuing these projects together. Thank you.
Thank you very much, distinguished delegate of the United States. I have next Argentina, Japan, the Philippines, and Canada. Please go ahead. The distinguished delegate of Argentina, as I said, please, if we can focus, as has been the last interventions, on the way forward, will be most appreciated. Argentina, tiene la palabra.
Argentina, you have the floor. Thank you very much, Mr. Chairman, for giving me the floor. It's my first statement today, so good morning, good afternoon, good evening to everyone in Working Group 2. I'd like to thank the Secretariat for organizing this colloquium and to the briefers as well for their excellent presentations, which we've enjoyed listening to throughout the week. On the specific issue as to what do we do with these two drafts we have on the table before us, the draft provisions on technology-related dispute resolution and expedited arbitration. On the first draft, my delegation does not see the need to create new rules which would specifically apply to technology-related dispute resolution. We understand that the current existing UNCITRAL arbitration rules, in particular expedited arbitration, are more than sufficient for effective implementation and the settlement of disputes related to technology. As to the second draft on the table, the study on adjudication, in the working document, we saw in that document and we heard in the various proposals that this is an institute which is regulated in some countries but is not regulated in other countries, and that's the case for my country. And that divergent or different treatment would mean that we would not be able to find a unified legal framework for resolution. And because of this different treatment in the different legal systems, it would really be a challenge to develop some kind of harmonized ruling on this. But we do understand that it would be viable for us to consider the creation of a harmonized legal framework within the working group, and that legal framework could go beyond the construction sector, which was the experience used by some countries. Thank you very much, Chairman.
Muchas gracias.
I thank the distinguished delegate of Argentina. The next speaker is Japan.
Japón tiene la palabra.
Japan, you have the floor.
Thank you, Mr. Chair. I wish to point to an issue we identified which may need to be resolved were this project on tech-related dispute to go forward. The issue of definition or scope of application is an important one, which will define what the work will be about. In this regard, it does seem that as we discuss more and more, the work exposes itself, at least to us, to be about developing provisions for disputes in which three elements, use of expert knowledge, speed, and confidentiality is of essence. This is perhaps what brings us to think that the provisions may be useful also for non-tech disputes. Having said that, I wish to recall that when we started this exercise, it was based on the understanding that there was a special demand from the tech industry to accommodate the sometimes conflicting interests. of use of expert knowledge, in other words, addressing complex issues and extremely speedy resolution of disputes. We are flexible and fine taking a generic or flexible approach, of course, with tech-related disputes in mind, but hope to flag that there seems to be an underlying question to be answered, which has a correlation with relevant issues such as whether to impose strict timeframes or leave it flexible. And so that brings me to the end of my intervention, and I hope that it will be of some help in contemplating the way forward. Thank you, Mr. Chair.
Thank you very much, the distinguished delegate of Japan. I think has been indeed helpful, your intervention. I have next Philippines and then Canada.
Thank you, Mr. Chair. As this is our first intervention, this delegation would like to thank the Secretariat for organizing a rich and comprehensive colloquium as a stock-taking exercise for possible future work. We also would like to thank all the experts that shared and made presentations on the different issues during the sessions we had for this week. If I may go back for the RDE, we concur with other delegations that we should be mindful that the principles of due process and fairness should not be disrupted or sacrificed, despite the benefits brought by the use of technology. On other technology-related issues, we concur that we should continue with this informed discussion and information sharing on issues so as to reconsider and evaluate comprehensively as a way forward on the possible future work of the working group, on whether it is feasible and necessary to create a new set of rules on mediation or the international use of adjudication, as well as on expedited arbitration. Thank you, Mr. Chair.
Thank you very much, distinguished delegate of the Philippines. Next and final request for the floor that I have is from Canada. Canada, please, you have the floor.
Thank you, Chair. Canada's interest in adjudication, I think, has been clear all week. So, of course, we would support looking at a cross-border system as well as exploring the application of adjudication, possibly in other areas than construction. We heard some good examples this week. So I will say a few words on the technology-related disputes. We also agree with Israel's suggestion, and supported by many others, that this topic could benefit from being done at the same time. We do note that some of the issues from the discussions this week, some of the issues for tech-related disputes may be best suited for guidance than off the rack, while others, it may be the opposite. They may be best suited for off the rack than guidance. So our general preference would be to develop something complementary or amplified for text disputes, so not to amend the rules. However, to borrow from the distinguished delegate from the USA, and I wasn't quick enough to capture her quote, but we could focus first on substance and deal with the form second. Thank you.
Thank you very much, distinguished delegate of Canada. I have a request from what I think is the last request, and then I expect to close the discussion from the Republic of Korea.
Thank you, Chair. I have two brief comments regarding adjudication. We would like to echo the distinguished delegation of China's view and questions with a view to studying the feasibility of setting a separate rule for adjudication. As for the technology-related disputes, while the draft provisions are very useful to develop our discussions, it is necessary to be a little cautious about establishing a separate rule for technology-related disputes. In that regard, we would like to echo the distinguished delegation of United States to discuss substance first and decide the appropriate form. Thank you.
Thank you very much to the distinguished delegate of Korea. We are approaching the end of our session, and as I said, I would like to deliver my commitment to finish. I have a request from the distinguished delegate of China, and unless there is other delegation, I will close the discussion after the distinguished delegate of China intervenes. So he will be the last. That will be the last intervention of our session. China, please, you have the floor.
Thank you very much, Mr. Chair. I'm speaking to clarify that participating in the colloquium, we have the Chinese government's delegation and as well as observers from China. CCPIT's colleague is on behalf of CCPIT as an observer, so his views do not represent the Chinese government's delegation. For adjudication, we support the continued discussion of it. And as for what forms of legal documents or instruments should be made, we do not yet have a mature or established position. But indeed, the views of our colleague from CCPIT does not represent those of the Chinese delegation. Thank you.
Thank you very much, the distinguished delegate of China, for that clarification. I think that it was clear, but it's understood and noted what you mentioned. So with that, I think we can close the discussion. I think there have been, I'm grateful to the different delegations for their remarks and for their contribution about the way forward. I think has been very rich and I think provide enough material to be reflected in the report that will prepare the Secretariat for the Commission. I just would like to point out two things before finalizing with respect to what I have heard. I think that we have heard support from different delegations for further considering both topics and possibly together. I think also we have heard from several delegations that express what are the certain issues or problems that they see with respect to these two topics on each of them. We have heard about the issue of adjudication of harmonization, the need from the domestic to the international area, which industries other than construction can be applied to, etc. Which it seems to me that it may suggest that it would be useful and interesting to conduct a form of a feasibility, a further feasibility study with respect to these issues in the way forward. At the same moment, also some comments have been expressed with respect to draft provisions on tech disputes, and has been several comments on how these can be developed and what are certain difficulties that are perceived, like the one we just heard from the distinguished delegate of Japan about the scope or definition. I want to point out at the same time that I personally thought that was of particular relevance, a comment made by the distinguished delegate of the United States when it was mentioned that one possible way of future work is to see how the use of the current rules, in particular the expedited arbitration rules, can be amplified without necessarily amending them in order to offer to users a broader application or a broader specific application of these rules. That's something I have to say come to my mind when we're listening yesterday to or reviewing the different draft provision, but also listening to the distinguished delegate of Japan when he identified what are the key issues that were, I would say, of particular importance in a tech dispute that can be also applied to other areas of dispute. I think that is a very interesting area to consider. Well, having said that, and that we are about to reach the end of our session, I would like to close the discussion now, but before closing the discussion, I would like to say a few words. As I said in the opening of the session on Monday, this is the 75th session of Working Group 2, an important milestone, but this session is significant in a much more meaningful way. This session is the last session of Corinne Montinieri with our Working Group 2. Today we say goodbye to Corinne, who is retiring from UNCITRAL after 20 years with the Secretariat. Corinne is participating remotely, like me, from her home in Vienna. So I will kindly ask her if she can turn on her camera for these last minutes of the session. And if you indulge me, I will use my privilege as a chair to say a few farewell words to her in the session. I remember the first day I attended UNCITRAL, the Working Group 2, many years ago, in New York, in a similar room that you are today. At the beginning of the discussion of the revision of the 1976 UNCITRAL arbitration rule, I was, of course, lost, trying to understand the dynamics of the discussion of the working group, what consensus meant, and when was appropriate to intervene or not, what to do, what not to do, how to act, how to understand what was relevant. And I asked a couple of prominent delegates that I knew from before for advice. And both of them, without hesitation, gave me the same answer: talk to Corinne. And that I did, and I have been keep doing since then. She became for me the source of wisdom and guidance. I would say the oracle of Working Group 2 has been she has been for all of us. She taught me, as I said, what consensus is, and more important, how relevant is the work that we do on UNCITRAL. During all these years at UNCITRAL, she has been the compass that has been shown the way to the working group to achieve its different tasks and endeavors. During the sessions and outside the room, she was who gave direction and balance to us, with a deep knowledge of the technical aspects of our work, but also with subtle diplomatic skills. She always pointed us to the path to follow to achieve our mandates. Corinne understands, in my view, better than anyone, the ethos of UNCITRAL and our working group. What is our role and how to perform it? She understood that the path to achieve a result is as equally important as the result itself. Without never raising her voice or losing her calmness, she was there to help us to find the best way forward. Corinne exercised what in Latin is known as auctoritas. Her wisdom was recognized by all of us. For all these reasons, and many more, she represents what is best of UNCITRAL and this working group: deep technical knowledge, work ethics, intellectual rigor, high standards, and the vocation of serve and help. As an old member of this working group, and as chair for the last year, I've been able to be a privileged witness of all her talents and work. Her contribution to the harmonization and unification of the law of international trade is immeasurable. Her imprint is in the conventions, model laws, rules, guides, practical notes, and instruments produced by UNCITRAL in these last 20 years. It will be difficult to get used to her absence during the sessions and not to have her company and guidance in the project. UNCITRAL is losing a key person. But knowing her colleagues at the Secretariat, I'm confident that they will maintain all the attributes Corinne embodies and that make UNCITRAL and this working group in particular a unique place and certainly a pillar of international commercial law. We will not try to bother you, Corinne, but I'm sure you will understand if sometimes we come back to the Oracle to seek your advice, a recourse I promise we will exercise with due prudence. But what we'll miss more dearly is the person, the friend. Corinne always, with a soft touch, had a time to listen and ask about you personally. She always had a warm smile in the good and also in the most tense and difficult moments. It is sad to see you leave, but we understand that it's time for you to start a new stage in your life after devoting all these years to UNCITRAL. Of course, we wish you the best of luck and all the best. But before concluding, if you allow me, I would like to use a few words from a Chilean poet, Pablo Neruda, one of our Nobel Prizes. And I would like to use one of the odes of Neruda, which is the ode to thank. It's an ode to the word thanks. It's a word that I think in Neruda's view, this word meant communication, creating bridges, but also the meaning of the word itself. And I think that represents a good way to say thank you to Corinne, but also to acknowledge that she created bridges, communicated, and she brought us all together. My only concession that I will do is that I should not read this in English, but I think it's better for me to do it that way because I don't want to put the interpreter to translate a poem into English. So I will use, so with the indulgence of our poets, I will use an English version of the poem. And the poem is Ode to Thanks by Pablo Neruda. Thanks to the word that says thanks. Thanks to thanks. Word that melts iron and snow. The world is a threatening place until thanks makes the rounds from one pair of lips to another. Soft as a bright feather and sweet as a petal of sugar, filling the mouth with its sound or else a mumble whisper. Life becomes human again. It's no longer an open window. A bit of brightness strikes into the forest, and we can sing again beneath the leaves. Thanks, you are the medicine we take to save us from the bite of scorn. Your light brightens the altar for harshness, or maybe a tapestry known to far distant peoples. Travelers fan out into the wilds, and in the jungle of strangers, merci rings out. While the hustling train changes country, sweeping away borders, then Spasibo, clinging to pointy volcanoes, to fire and freezing cold, or danke, yes, and gracias. And the world turns into a table. A single word has wiped it clean, plates and glasses gleam. Silverware tinkles, and the tablecloth is as broad as a plane. Thank you, thanks, for going out and returning, for rising up and settling down. We know, thanks, that you don't fill every space. You're only a word, but where your little petal appears, the daggers of pride take over, and there's a penny worth of smile. Thank you very much, Corinne.
Thank you.
And now,
thank you so much. Thank you so much.
and now I would like to invite the working group and all the delegates to an informal farewell that we have prepared to Corinne in the following link Zoom that will appear there in your screen. So I invite that we will start in 15 minutes or a little less than 7 minutes, and I invite you all to give farewell to Corinne. And now, I think all please join me in a big round of applause for Corinne. Thank you very much.
Thank you. Thank you very much. Merci beaucoup. Gracias, Yeseni. Shukran. Merci beaucoup. À tout à l'heure.
See you in 5 minutes.
See you in 5 minutes. Thank you.
And with that, we close the session of this week. Thank you very much to you all.